Well, good afternoon, everybody. On behalf of Freeman, Mathis, and Gary, and our partners in today's webinar, Miles Mediation, I want to thank you all for joining us. I say good afternoon, but in some cases, I think it's possibly good morning. And wherever you are, we want to tell you how much we appreciate you joining us today. My name is Andy Treese. I'm of counsel at Freeman, Mathis, and Gary in our Atlanta office, where I split my time between our complex litigation, catastrophic tort team, and our government liability team. I want to spend just a moment before we get to the substance of the webinar, introducing who our panelists are today and talking about the logistics of what we'll be doing today. So as I go through, I'd like to first introduce my colleagues at Freeman, Mathis, and Gary. We're joined today by Jennifer Markowski. Jennifer, if you could wave. Jennifer is a partner in our Boston and Providence offices, where she practices primarily in the areas of professional liability and labor and employment. Jennifer Adair is with us as well. Jennifer is a partner in our Atlanta office, where she practices primarily in our complex litigation, catastrophic tort section, as well as our construction section. We're also joined by Ken Menendez. Ken, if you give us a quick wave. Ken is a partner in our labor and employment section. He's also a specialist in complex litigation. Ken also, I have learned, is a published author as well as an arbitrator and mediator. So we're glad you could join us, Ken. Thank you. And certainly last but not least, I want to thank our partners at Miles Mediation for joining us today and just introduce them very briefly, and then they'll introduce themselves more when we discuss mediation. I'd like to start by introducing Greg Parrott. Greg's a senior mediator at Miles Mediation. He has a background on the defense side, on the plaintiff side, and on the claim side of things. We're also joined by Susan Forsling. Susan is a former city attorney. She's a veteran mediator. She's also a former judge. I've used her before on a lot of cases. She's very good at what she does. Susan, thanks for joining us today. We're also joined today by David Nutter. David is a former U.S. attorney. He's a trial attorney. He's mediated over 1,600 cases. He's very well respected, and we're glad that you could join us, David. Thank you. So before we get into the substance of the presentation today, Greg, I wonder if you could spend just a moment explaining to people the question and answer feature on the Zoom call in case they want to send any questions along to us.
Thank you, Andy. If you look at the bottom of your screen, you'll see the Q&A button. If you click on there, you may submit anonymously questions for us to respond to. We will try and respond to them in the course of our conversations as we're presenting, if they're relevant at that time. Otherwise, we will save them till the end and try and address everyone who submits a question. And we'll do it anonymously. Thank you.
And so thank you for that, Greg. I want to spend just a minute setting the stage for our conversation today, right? The world has changed. In the United States, it changed effective early March. I think my partner, Mark Bardak, and I may have gotten the last civil jury verdict we're going to see for a while on March the 13th. Our profession has changed, and it's because of the coronavirus pandemics. We're not going to be discussing the ins and outs of coronavirus or COVID-19 today, because what I want to focus on a little bit for purposes of this call is an issue we've been getting calls about from our clients, both the insureds and claim professionals. We get calls in some cases from opposing counsel asking, how does social distancing affect our ability to move cases? Can we still move a case? How far can we move a case? Or is everything just going to have to be on hold indefinitely? The answer is almost always that there's at least something we can do to move a case forward. In fact, there's a lot more that we can do to move cases forward that I don't think people were always able to understand. So what we're going to do today is talk a little bit about the use of remote technology in litigation, first in depositions, then in mediations. And I'm not talking about it yet in the context of trial, but I suspect that over time and over the months and years to come, some of these principles are going to emerge, and we're going to see more and more remote live testimony at trial as opposed to videotaped and video recorded depositions. So I do see we've already got a question coming in about privacy concerns on Zoom, and I am going to suggest that we wait on that one until we discuss the mediation portion, but we are going to get to that. What I'd like to do, though, is start off by asking Jennifer Markowski and Ken to begin a discussion for us about the use of depositions and whether remote depositions are really effective, and are they a cure-all for our problems?
Thanks, Andy. You know, for a lot of folks on this call, I'm sure that remote depositions are not a new thing. We've been doing this for a long time, remotely, over the phone, video depositions, but the difference is that now it's become a necessity. So a lot of lawyers and clients and claims professionals are now having to learn about this, whether they like to or not. So let's start by talking about the process for remote depositions. Jennifer, can you take us through that?
Sure, thanks, Ken. So as you mentioned, for a number of people, you're probably already familiar with the technology, maybe have participated in the past with it, but I think now, day to day, we're considering this as an option. And it's very similar to what we have set up today, where we have a number of participants that are in all different locations, but are able to communicate effectively with one another, both by video and also by audio. So there are a number of different platforms that are available. Zoom, which is what we're using today, I think is probably one of the most popular platforms, but we also have Microsoft Teams, Skype, and I'm sure a number of other different kinds of technologies that are out there, all of which achieve, you know, similar kinds of results that we have here. And participants can participate both with the audio and the video as well, or you can just participate via audio. I think the video is one of the biggest benefits though, and that's why it is really helpful in litigation to use this for depositions. And the other thing I would mention with regard to depositions, we'll talk a little bit about this, but you have the ability to share exhibits with one another on the screen. You can share your screen and show folks what it is that you're asking a witness about.
Which is always one of the big challenges. So Jennifer, why would people choose a remote deposition?
Obviously, you know, current times, the situation, coronavirus situation, I think it's really causing people to take a step back and think about what can we do to service our clients to allow us to continue to move our cases along. And to help our clients get to some sort of resolution. So I think we're all taking steps back to think about how we can do that. This is actually a great way. Depositions are obviously very critical and important for the litigation process. And this is a mechanism for us to be able to continue to do that while also practicing social distancing, you know, staying remote and separate from one another. And the other fantastic thing about it is that it's actually very accessible to just about everybody. If you have a smartphone, a laptop, a desktop, you can connect and use Zoom technology. So it's very accessible and to just about anybody, and it allows for us to continue to move our cases along and service our clients. And I think really it's probably the next best scenario to an in-person type deposition.
As you know, Jennifer, we've had discussions in our firm about whether or not every deposition is a candidate for a remote deposition. What's your thought on that?
I think not every deposition, at least insofar as we have hope that, you know, the months down the road at some point we will emerge from this and be able to go back to taking depositions in person. I think it's a time to consider what depositions we can do remotely and what ones we might want to save for a little bit later down the road. In particular, key witnesses, maybe a plaintiff's deposition, particularly if there are issues about credibility. There really, I don't think is a perfect replacement for being in person with somebody if you're trying to size up that person's credibility, their mannerisms, how they present in person. And similarly, on the flip side of it, if I'm defending a deposition and it's my client, it's a key witness, I might be a little bit more reluctant to have that deposition go forward where I'm not physically present in the room with that individual. So I think that there are circumstances where you might want to hit the pause button and think, let's save this one and see if we can, put this off a little bit further down the road, and then focus on some of the more, maybe less critical witnesses, people who credibility is not such an issue, or there's a very, limited scope of testimony that you're looking for. Those are often great candidates for doing a video conference deposition. I think also experts are particularly amenable to video conference deposition. Unlike, most witnesses in a case, they probably have experience with deposition. So you don't have those usual jitters that a lot of witnesses have. So, they're nervous about the deposition. They're also nervous about the technology. In a situation where you have an expert who is experienced, it can probably go a little bit more smoothly and you have less concerns about that. And there are probably less issues with credibility generally, and it's more focused on the substance of the testimony itself. So I think experts are often, good candidates for having a video conference type deposition.
So let's talk about that. Once the decision has been made to go ahead and have a remote deposition, what are the things that lawyers and claims professionals and clients should be thinking about as they get ready for that deposition?
Yeah, so preparation is really critical. I've seen a number of different approaches and things that have worked well and not worked well. And I think preparation, obviously we all have taken depositions and know what we're doing with regard to that kind of preparation, but it's really the technology piece of it. And then also just being in different locations and kind of getting a feel for that. So, really basic stuff, like you want to know where people are going to be. Where is everyone going to be located? And is everyone in a different location? Is the stenographer with a witness? Is the witness in the stenographer's office and the stenographer is elsewhere? Where you want to think about that aspect of it, both from a client preparation perspective. If you are defending a deposition, you want to make sure that they're in an appropriate location and their surroundings are appropriate. And then also just for, yourself as well and being a participant and kind of thinking through how is this going to work? Will I have the privacy that I need to have? I know in Massachusetts, as far as depositions go, the only people that are allowed in the conference room are the attorneys, the witness, and the stenographer, and then the parties. So you want to make sure that you maintain that level of confidentiality that you typically would in a deposition. So, thinking about things like the surroundings. And then also thinking about equipment, making sure that, the witness has the equipment that he or she needs. Court reporters are very good about offering up if there is any equipment needs, technology, things like that, and preparing for that. So have conversations with the stenographer ahead of time, work through those issues. Think about things like lighting, microphones, speakers. I know I've been on a number of Zoom conferences where somebody's saying, I can't hear you, and you're cutting out, and you definitely want to go through the technology ahead of time and make sure that you've tested it all, you know what you have, you're in an appropriate space, it's confidential, people can hear you, you can hear them. Those really sort of, basic type issues. And I would say the best way to know whether or not you're in a good position to do it is to have a test run, at least one test run, if not a couple. If you were defending a deposition, I would say do all of your preparation via video conference. Use the platform that's available, and so that you start to get comfortable and your witness starts to get comfortable with it. Have a conference with the stenographer using the technology, with opposing counsel, the same. For a lot of people, this is somewhat new, so we're all getting used to it. So definitely do some test runs with it before the actual deposition.
You mentioned defending a deposition. Are there any specifics that come into play when you're defending a deposition remotely?
Yeah, so, for me, I think confidentiality and communication with your client are the most important. When you're physically present with that individual and you're in a room, it's very easy to say, we need to take a break, we're going to go speak, and you can do that. So when you're in a deposition and you're doing it via video conference, your client is maybe more focused on what he or she is saying and maybe doesn't realize that you're the one that's speaking and objecting. So you want to have the conversation ahead of time with them and remind them about those things, like listen to when objections are being made, listen to who's saying it, and remind them that there may be times when we have to take a break and we need to communicate. Make sure that if you're using features such as chat rooms, I know Zoom has that you're comfortable with that, and that you're in a private chat room, and make sure that you have the person's cell phone number. So that's probably the safest, best way is to mute yourself, turn your video off, leave your room, and go have a call them on their phone or send a text message with your witness. So to me, that's probably the biggest issue, is making sure that they're comfortable with the technology and that you also have the ability to communicate privately with that individual throughout the course of the deposition.
How about things like marking exhibits?
So there are a number of different ways that I've seen this come up and how people prepared for it. Everything from somebody who takes all of the exhibits ahead of time and mails them out, or emails them out days ahead of the deposition. Preparation, I think, when it comes to the exhibits is really key. You want to have your must mark exhibits. I know I'm going to use these, and you want to have them ready and saved via PDF. And you also want to have, whatever exhibits that you think you might need, but it's an if, it's a maybe, maybe I'll use it, maybe I won't, but be prepared, have it saved electronically, and communicate with opposing counsel about how you're going to be handling that, so there aren't those surprises during the day of the deposition. If your plan is to email them out the morning of, make sure that people know that. I mean, typically we show up at depositions and people don't get the exhibits ahead of time, they get them the day of. So be thinking about that. It's a different way of handling it. Do you want to send stuff out ahead of time? How is that going to work? How does that impact your case? And certainly having backups available and having things saved electronically, and having conversations with counsel ahead of time about how that particular issue is going to work. In practice, and we'll talk about this I think a little bit later, the sharing of your screen, because you can share exhibits via a video conference features. So practice that and be comfortable with using that in the course of the deposition.
Well, we all know that the exhibits can be the bane of our existence at a deposition, so even more so remotely. So let's bring it down to the bottom line. Are remote depositions effective in your view? And is there a single point that our audience should think about when it comes to remote depositions?
Yeah, absolutely. I think that they are effective. I think they can be very useful in a lot of different contexts. And I think really preparation is probably the most important thing to keep in mind. Be familiar with the technology, do lots of trial runs, get it set up, make sure if you've got a client that's involved, they're very comfortable with it. I think that's the most important part of it. And then also just be prepared to kind of roll with it if something comes up. I mean, it's technology, things do go wrong. And you just need to be adaptable so that you're prepared for, whatever. You take a step back and, figure it out. We've certainly had circumstances that have come up in the course of different mediations and depositions where you just have to figure out the technology and kind of roll with it. So, preparation and adaptability, I think, are really important in this area.
So in that sense, I guess the coda is it's the same as we've always been doing: preparation and prayer. Preparation and prayer.
Yeah.
So let's talk a little bit about mediations. I'm going to ask Jennifer Adair to take it over.
Jennifer, you're muted.
The next topic that we wanted to talk about is a remote mediation, because while depositions are something that most practitioners have been doing remotely for some time now, the remote mediation is pretty new. And I think that even the concept of remote mediation kind of flies in the face of what we used to think about mediation. We thought we all had to be in the same room. We thought we had to lock everybody in a room and put some pressure on them and force them to settle a case. And we can't do that anymore due to social distancing concerns. And what we're finding, though, is that there are alternatives that are absolutely effective. And we're going to have a conversation today with some people who are the best in the business at making this happen. And one of the reasons that we chose to partner with Miles on this is because having a mediation take place remotely depends in a great deal on an experienced mediator who is familiar with the technology and can facilitate the technology so that the participants are not focused on the logistics. The participants, the attorneys, the parties, the mediator need to be discussing the merits of their cases, the value of their cases, and need to be focused on the negotiations themselves rather than how does the camera look? How do I build out a breakout room? How do I chat? And identifying a mediator who is able to facilitate this, to remove all these extraneous distractions, is important. We feel like Miles is regional in the Southeast and is at the forefront of facilitating a remote mediation so that the parties can focus on what's really important. And we are going to have a conversation with 3 mediators from Miles today, and that is Susan Forsling and David Nutter and Greg Parent. They have had considerable experience like us. They've had to immediately adapt to a new world that nobody anticipated a couple of months ago, and would like to talk to them about what they've observed in the time they've been doing this. So David, I'd like to start out with you first. Why would we want to have a virtual mediation, and why don't we just wait until this is all over?
Well, Jennifer, thanks, and thanks for Freeman Mathis setting up this platform. We're honored to be a part of it. You know, that question to a father of 5 children is like, you know, why do you run out of your house when it's on fire? There's a certain necessity and a duty that you have to figure out a way to keep things moving. And, you know, in the legal industry, we have a little slice of that, and we need to keep cases moving. And honestly, everybody's got to figure out how to do their thing, maybe in a new way. And I always, you know, Greg and Susan, I always like to use historical analogies, but the great Dunkirk escape occurred out of necessity. Churchill's like, I can't surrender my whole army. I've got to get these people back home. And so out of that necessity, human beings are amazingly adaptable, as Jennifer Markowski was saying. And some amazing things come out of it. You know, there's a proverb that says, he who is slack in the time of distress doesn't have much strength. I think we're going to find we're all going to be much stronger by engaging. And most of us, people in the legal industry, are not sit at home while the house is on fire type people anyway. You want to do something. You want to engage. And what we've been surprised, honestly, at how effective Zoom mediation, virtual mediation is. And cases are settling, and there's reasons for that. And so it's an opportunity really for both sides. Both sides have a necessity, a bottom line necessity to move cases, and there's a cost associated with not moving cases on both sides. So everybody's got to figure out a way to keep the court system going. And I would put it to the legal community. We're thought leaders, we're community leaders. We honestly have a duty to make the legal system keep functioning. You cannot have a society where the legal system stops functioning for 2, 3, 4 months. That's just really not an option. And Zoom is a way for us to bridge to get to the next place. You know, Churchill after Dunkirk said, a great retreat is not a victory. And you need to remember that. But this is a great way to bridge us to the next place. And we're finding that it is really working to keep the cases moving.
Thank you. Dave, could you explain to us how the process for a virtual mediation works?
Yeah, one of the things we have found, and I think it's kind of similar to what Jennifer was saying in the deposition arena, is pushed everything back. And so now I'm encountering plaintiffs and their attorneys 2 weeks before the mediation, where I would maybe have a phone call with the attorney 2 weeks before, but I would never be meeting the plaintiff 2 weeks before. That's proved to be a good thing, because that whole icebreaker activity has already happened by the time of the mediation. Hopefully they've kind of gotten comfortable with me and feel a rapport. And so it's speeding up that process. I'm finding on both sides, defense lawyers are now 2 weeks early saying, hey, if we want to do this mediation, I've got to have these docs, instead of like 2 days before the mediation saying, gosh, we need to cancel and reschedule because we don't have them. And it's actually pushing everything earlier, and it's aiding the process and making it more efficient. I think we're actually seeing fewer cancellations for those kind of document glitches and that sort of thing. And it's a matter of people getting comfortable with it. But you know, once you get past the process, part of growing stronger, I think, is I believe we're going to be having Zoom meetings with clients and lawyers and adjusters in advance more and more and more, and it's going to facilitate the process. And we may find that by the time you get to the in-person room, it's changed the whole character of the way mediations operate. So it's really changing the process as we sit here. And I don't think mediation is ever going to be the same again. We're going to still meet in person, but it's not going to be the same as it was. It's going to be better, honestly.
How do you use Zoom technology to facilitate a mediation? We don't have a caucus room. We don't have a water cooler that we can sneak away and chat by. How do you use Zoom technology to make it work?
Yeah, and Greg's going to talk more, I think, about the security piece of it. But I know all of us at the front end, as people are getting used to this, explain the security piece, which Greg will do. But the virtual rooms is really kind of amazing and crucial. I can share a humorous story in that way, but we do all of our meetings, substantive meetings, in the virtual rooms, the breakout rooms, which is an added level of security. And so I had a mediation last week. It was a multi-party case. It was one of those situations, Jennifer, you and I have experienced before, where one of the defense lawyers had to move from room to room, to make it happen. And there was coverage issues and this sort of thing. And I was able to bounce him around to different rooms very easily. Of course, he's remaining in his home. He's not actually moving, but it sure does have the feel to him and to me that he's moving. And it worked. We were able to get a fairly complicated matter resolved, and he was able to get private with each group. When you're in these breakout rooms, no one else can hear you. And it's very easy to demonstrate that to people. And then the conversations you need to have happen, and I can move him to another room. So I was mediating another case last week with a plaintiff and his lawyer. They were really kind of out in a country county. So the plaintiff came to the lawyer's office, and they observed social distancing, I promise you. But he came there to be in person with his lawyer there across a conference table. And it becomes so real. This is really funny, but I said, okay, I'm going to move you, lawyer, into the joint room and then come back and get the plaintiff. And they all kind of paused and they said, David, we're literally in the same room. When you move one of us, you're moving us both. And, the power had kind of gone to my head, but I couldn't actually move him. But it feels that way. And it actually, there's a privacy with the plaintiffs when they're in their own comfort zone that we're finding works. They are just in their home, they're comfortable, and yet they feel totally engaged with the process. So it's been an amazing thing to see how those virtual rooms work. It's a great process.
As a lawyer, I like to make a presentation when it's appropriate in an opening statement using PowerPoint, showing documents that may rebut some of the other parties' contentions, showing photographs, showing animations. Do I have the ability to do that within the Zoom platform?
Yeah, absolutely. And again, it's remarkably effective. I can pull up just the Miles mediation settlement memo here in a minute. Just to show that, but I have had lawyers do PowerPoint presentations, share accident reports, damages calculations. I had a plaintiff's lawyer last week that shared links. And so on the screen share, you could click on the link and it gave you a whole additional set of information that everyone could look at. And it's really, really easy. And so anything you have pull up on your screen, you can share. So this is a simple example. I can click on the Miles mediation settlement memo, the simple one, and share that. And everyone ought to be able to see that. And if we wanted to get to an agreement, I could do Jones v. Smith. Oops, one M only. And you get the idea. And then we can go on to another document and so on. And then when we're ready to take that down, you stop share. And here we are back. It's incredibly easy. And actually on the screen, I find people are focusing on it more, honestly. They're paying closer attention than they might even on a PowerPoint when there's other it's the only thing right in front of you. So once again, it just has proved to be a very effective way to communicate your message.
Thanks for that, Dave. Greg, I wanted to talk to you about what we as litigants should do in order to prepare for a virtual mediation. Can you talk to us a little bit about that?
I think David hit the nail on the head, Jennifer. You're going to have to prepare a little more thoughtfully and a little more upfront than you might normally do. There's certain things, certain documents that you're going to want to get to me earlier, especially if one of the litigants doesn't have the technological savvy that David has or other folks might have. You know, it's a unique time. We're presuming everyone has a smartphone, a tablet, or a laptop computer. Some people have desktop computers, and as you said yourself, there's been a run on things at Best Buy and everything. You can't get a webcam for 2 months now. So we have to kind of assess what the technological abilities are, the litigants. And sometimes you have folks who, you know, due to the nature of an accident or an injury, they don't have the ability to participate in Zoom. So part of what I'm doing is reaching out to folks early. Like David said, he's talking to plaintiffs and plaintiffs' attorneys 2 weeks earlier. I'm seeing the same thing. I host a lot of tutorials where I sit down with the parties and show them how it can be done. It is very cathartic. You see people literally on the screen going, oh, okay, this isn't some Star Trek crazy thing. This is going to be something I can do. We're getting invited to people's homes, Jennifer. So what we're able to do, like if you guys look at Ken's pictures, earlier when he came on the screen, I asked him about who the little baseball player was, and he proudly said, that's one of my boys. I'm able to do that as a mediator. When I look into people's pictures, I can look and go, wait a minute, is that Wrigley Stadium? Am I talking to a Cubs fan? Am I in the wrong house or something like that? And you see people feel comfortable, because in a normal mediation, they're out of their element and they're coming to our office. And so they're not in their home surroundings. When they're in their home surroundings, I'm finding that it allows us to be more connected to them and allows us to really meet them where they are. And so to answer your question directly, from a preparation standpoint, I'm ascertaining what their technological abilities are. And there are folks who do have the ability to use this, but don't trust new technology any farther than they can throw it. And they'll insist, I'll be available by phone. I'm like, well, I can just put you on I'll be available by phone. Phone it is, okay. So that person will be available by phone. And there are times I've done 12 mediations now virtually. And one of them, I had a person on the phone, I had a person on FaceTime because they weren't allowed to use Zoom. And we're facing that where certain companies aren't allowing their folks to use Zoom. And what we've undertaken at Miles is a 4-step process to ensure the safety as best we can on this platform. And I actually think it's safer than an in-person mediation for several reasons. But our first thing that we do is we send out a unique Zoom link. Each mediator has a unique Zoom link that we send out, and only the recipients of that link can come in. And what we encourage folks to do is to treat it like you would in real life. In real life, you don't go on Facebook, Jennifer, and say, hey, I'm mediating this case, and you don't put all your facts out there for the world to see. So you'd no longer share that link with anyone than you would share your mediation memo that you'd send to me with the world. So there's some common sense that goes with it, but they'll get that unique Zoom link, and then they get a unique password that changes. So those are 2 first-step elements before they can even get onto the call. Once they do sign in, they are forced to wait in a waiting room. And that waiting room is controlled by the mediator. So even if someone were trying to somehow get in and Zoom bomb the process, they're stuck in a waiting room unless or until, and this is where I get like David Nutter, and I wield my power until I let them in. So no one can come in. So you have that factor. And the final thing is when they come in, much like when you come to the mediation facility in person, I figuratively, virtually walk them to their room and I put them in their room. So those are 4 steps right away. The 5th step is that we lock the process. Once everyone is on, like the panelists here are on, I lock the room so no one else could get in even if they wanted to. So it's virtually lock safe. And when you're in the breakout rooms, what happens is I preset the breakout rooms, and I always do a couple of extra ones. So for a standard 3-party mediation, I'll have the plaintiff and her attorney in one room. I'll have defense counsel and her adjuster in a second room, and say coverage or coverage counsel and his adjuster in a third room. Each of those pairs are in 3 rooms that can't talk with one another. When we come into the room, I talk with them, and then when they want to talk and send me out, Jennifer, you may say, Greg, let me talk with my client for a minute and we'll get back to you. I excuse myself, and then you have to call me back into the room. So I can't interlope, I can't sneak in, I can't hold a glass jar to the door and try and listen in. I don't come in until you let me come in. So those are some of the safety items that we have, and we're finding that it's tremendously safe. Additionally, we take off the ability to record the process. In the real world, someone could theoretically come in with a recording device, keep it in a purse or a knapsack or their coat pocket, and we'd never know. But here with the Zoom process, I can disable the recording feature. They can't record it. I can also disable the chat save feature. What we're finding too is what I tell my clients, Jennifer, instead of using the chat feature and mistakenly hit a message that you send to everyone, I get everyone's cell phone beforehand. I also get the cell phones and emails so that I can have a redundant system. With technology as it is, with everyone homeschooling, I have to be the webinar Gestapo, and I tell my kids, only the essential computer you need for school when I'm on a webinar or when I'm on a mediation. No Netflix, no downloading things, no Xbox while dad's working. And that's to try and keep my bandwidth. But if we do lose people, not everyone has the same bandwidth, I get to call them up on the cell phone and we kind of patchwork it in and get it to be effective again. But those are some of the features that we've had and some of the ways we've adapted it. The biggest thing I see, Jennifer, is when, like David alluded to, when we take time to meet with people, it's a time savings thing for a couple of factors. We're getting to hear about the case anyway and learning about like what Jennifer Markowski was talking about, labeling exhibits and things of that nature. We're covering some of those things, and I'm getting my head around whether I need to be doing the screen sharing, so they send it to me and I'm the facilitator of that, or whether they're savvy enough to do it on their own. But something David mentioned and I thought was great, when we see the plaintiff again for the second time, it's almost like a reunion. They see us and they're like, oh, there's that guy with the goofy bald head that I remember meeting the other day. Oh yeah, he made me feel comfortable. And we hit the ground, instead of starting in the end zone, we start on like the 20-yard line, and we're moving the ball down the field that much more efficiently.
All right. Thanks for that, Greg. And you raised an important point because technology can fail. Internet does go out. I've had that happen myself. And I think an important backup point that Zoom offers is there is the phone number that you can call in. It's not just a private conversation between me and Greg. I can dial in and I can be an audio only participant in a Zoom call and not really be left out of the entire process. So I think it's important that there is that backup in case the technology fails. Susan, I wanted to move on and ask you a few questions about some strategic considerations. First of all, are all cases appropriate for a virtual mediation?
That's a good question. I would say that most are. There are a few with either technology glitches. I had one where there was a translator and that became important. But for purposes of this group, I would think the number one determination would be whether or not counsel believes that an in-person mediation would be more effective to get a particular party either focused on or appreciating the risk that the mediator is presenting so that it creates that dynamic of compromise or that settlement tension. Sometimes there are certain cases with certain kinds of people that in the judgment of counsel, it would be better to do in person. But having said that, I have done all kinds of different cases and done them successfully by Zoom, different topics, multiple parties, coverage kinds of questions, document intents, all kinds of things. So I think absent an opinion of counsel, that I'd say the majority of these cases are in fact appropriate and would do well in mediation.
Something that has surprised us is the virtual platform kind of opening up new opportunities and a chance to really think outside of the box about what a mediation can offer. Can you explain that some?
Yeah, and as a senior judge, I think I'm particularly tuned into this. Our courts are pretty much shut down. And then consequently, there are certain log jams that keep a case from really going forward because of that log jam. And until the court can address it, the log jam is going to remain. So I got to thinking there's certainly some appropriate ways through mediation and arbitration that the parties can move through these log jams. And so, of course, one of the first ones I thought about, probably in order of the things I know judges don't like to deal with anyway, is a discovery dispute. So for example, if you've got one involving just, volumes of documents, you've got one involving either a privilege or a protective order, or as we see more and more, you've got a dispute involving e-discovery where somebody wants to take control of the other person's computer, or you're arguing over search terms. Those are things that I think can easily and effectively be mediated. Or even arbitrated. David Nutter said to me the other day, Susan, anything can be arbitrated, if the parties agree. So I thought that was one example. The other thing that I thought would be a really important example was Daubert Motions. This would be ideal for Zoom if the parties would agree to arbitrate that, because you do need some kind of a finality of the decision. But think about this. You could bring in the experts who are the subject of the motion. You could bring in the experts who are opposing it or agreeing with it. You could have the parties argue, because these things are complex and they are long if they are done right. Again, judges, some judges aren't exactly fond, I'll use that word, of them. What a great way to do those by arbitration. And as you know, the reason that really helps with the logjam is oftentimes, depending on that ruling, there's a motion for summary judgment that would be appropriate to be filed, and that case can move along. So those were just some examples that I was thinking of that might be a helpful way to keep the cases moving, despite the social distancing, and in our case, the courts being shut down.
Sure. And when you mentioned bringing in experts, something that I have thought about in past mediations, I have paid to bring in an expert for the opening statement to explain what his opinion is to the other party, so they don't have it filtered through their attorney. They can hear directly from an expert, directly from a doctor, from a witness, an accident reconstructionist. It's expensive to do that, though, and not every case merits that expense. But when we can do it by Zoom, and I'm not paying for the expert's entire day, I'm paying for 15 minutes, will you pop into this mediation and explain why we don't think there's causation? It really does open a new world of possibilities for who can participate in a mediation and who can contribute to a mediation. So I think that there are a lot of opportunities for everyone to start thinking outside of the box as to how they can now share information that they would find persuasive.
And I think that would be really helpful in the mediation context, particularly with experts, and particularly if you're dealing with clients who are lay people. For an example, if you had an accident reconstructionist put up that video animation, it would just, wow, in the opening, instead of a mediator saying, well, you can expect to see a video animation, or, hey, look, I think this is what their doctor's going to say. If you go to court, so you're going to have a causation issue. Wouldn't it be much more effective, instead of that statement, to have the doctor up there front and center saying, hey, let me just tell you what my opinion is. And so then the mediator can say, look, having seen this, you just be aware this could be very, very compelling in front of a jury. I think it'd be extraordinarily effective for not only the parties, but it would help the mediator do what the mediator is supposed to do, which is explain risk to the respective parties.
And with that, Susan, I want to ask you a question, and then I'll ask the others to chime in as well. But how are your clients responding to virtual mediation? What kind of feedback are you getting?
I am very surprised, but it has been 100% positive. I've done everything from trucking cases, med-mal, all kinds of people. And without exception, they have said this is surprisingly easy to navigate. Again, because hopefully we're all well trained and we make it easy for them. They have all said to me, I don't feel like I lost anything. I felt like we could all really communicate well with one another. And to the point that was previously made, I felt like I was in the room. I didn't have any of them feel that, that this was a substitute or a second best scenario for the mediation. And I've been very intentional after every mediation to following up and saying, What do you think about it? And I even had one lawyer call me afterwards in our medical malpractice case, thanking me. And she said, Susan, I couldn't tell you this, but this adjuster is going to be retired before we could ever get this case mediated. And Susan, I needed this to get done, and thank you for that. I had another person call me and say, Susan, thank you. My client is disabled. I don't know when she would have been able to get to Miles mediation. So I'd say the feedback for me so far has been universally favorable. And again, nobody's feeling like this is some kind of a poor substitute.
Dave, are you getting similar feedback?
Yeah, you know, when this first came down and we were all going to have to move to this platform, I think we all felt like, gosh, I'm starting the first grade again. And you get that same feeling as when you were 6 years old. And it's the same for the parties. But once you get into it, you're like, this isn't that difficult. Once you get it's not that, you're truly not sending a rocket to the moon. It's not that complicated. And at the end of it, you realize, I'm at home, man. I don't have to drive anywhere to get back. You know, there's some benefits to it, and there's a comfort level that I think everyone realized, oh, this actually works. It's easy, and I'm home when it's over. So, you know, I've gotten totally positive feedback like Susan has.
Well, and Greg, other than the fact that we're not getting free lunch anymore, how has the feedback been for you?
I've had similar feedback. You know, the cases that should settled. The ones that had some difficulties naturally had difficulties. The platform was not a factor either way. Most of the cases that we've seen were already scheduled, at least with David, Susan, and myself, well before this COVID-19. So we're not seeing anything that had to do this. There are some cases initially that said, you know what, there's something about a Susan, a David, that we need those folks. And I felt it, I experienced it too. We need you in the room, so we're going to push back. But those cases of now realizing our new normal isn't really changing anytime soon have come back on, and I'm getting the email of, when can we meet, and when can you take me on that tutorial you promised? So we're starting to get those cases back. The thing that I've missed, and you mentioned the lunches, people miss the lunches. I'm tired of deli sandwiches. I miss our lunches too. But what we're really missing is, you know, mediation has become the calendar call, so to speak. On any given day, with 10 mediations going on, there could be upwards of 20 to 40 attorneys, you know, 10 claims people there, and people are missing the socialization. The very first mediation I had, someone said, wow, that was surprisingly good. Can't believe how effective. And I still can't wait to get back to see people in person. So that part I don't think is going anywhere. As David said, I can foresee this changing for a positive way. Think about this. In Atlanta, our worst day of traffic is Halloween, correct? And for those of us with kids still going trick-or-treating, there's always the pressure to get back. I can see people saying, hey, this one's on the 31st. We're Zooming, right? Yeah, we're Zooming. Or if there's a big Georgia game, or people are trying to get out for the Georgia-Florida cocktail party, or different things like that. Or, you know, we're hosting Final Four, Super Bowl. I think Atlanta has some unique challenges with traffic that people are going to say, can we Zoom? And then Susan hit the nail on the head. Where you have a sick person, where you have someone where they're elderly, instead of missing out on this process, we're going to be able to Zoom. And I think David's done one where he's been with one of the parties in person and they Zoomed in the other folks. I think those options are going to be there.
Yeah, we did. I did do one where the plaintiff's lawyer really wanted me to come to his office and again, you know, observe social distancing. We Zoomed the beginning, so he and his client were in separate rooms and everyone Zoomed. But then after that, I was able to meet across a table with the plaintiff. I think as much as anything, it was just a comfort level for that attorney, because honestly, there was another attorney who was Zooming with the client that I think that communication helped get the case settled. But there's hybrid things you can do. And as Greg said, you know, my 14-year-old with some chagrin observed this last night. She said, I guess this is the end of snow days. And it's like, yeah, I think it might be the end of snow days. That's a good thing for us who earn a living, but for the kids, they're kind of bummed out about it.
Jennifer, you know, seeing one of the questions, someone asked, are the mediations going longer? I think the mediations are still going how they should go. I've had some go 7 hours, 8 hours. I've had some get done and wrapped up and completed in 2.5 hours. The one thing you are missing is my finger click is way faster than my walk down the hall, so I'm able to join in. One thing I was surprised about is on a 7-hour mediation, I might have left my chair at one time, so I was just immediately going back and forth. I may have to build in some bio breaks as a mediator, but other than that, there's not really a challenge that we're facing as far as being effective in this new virtual reality.
Susan, are you finding that it's difficult to build a rapport with people when you can't be in the same room with them?
Well, I think it just takes a little bit more effort. Take a little bit more time with, for an example, let's just say a plaintiff. I always like to talk to the plaintiff in the morning. If you do what David does, then this is your second time with them. But ask some questions. And I've been asking questions like this. Are you comfortable with this platform? Do you have any questions about it? Do you have any concerns? And I think once they feel comfortable at addressing, the only thing I have seen is that I have seen lay people, plaintiffs, are reluctant to talk. And so what I've tried to do is really try to engage them early on things that have necessarily nothing to do with the mediation. But then as we go forward, I'll say things about, well, Miss So-and-so, what do you think? Hey, is this making any sense to you? Just continually asking questions that I might not have to ask if I was sitting across. But overall, I would tell you that I haven't felt that I've had an inability to either connect with people or get my messaging across to people.
An in-person mediation allows us to get the parties who are the decision makers there for an entire day, shut in a room with no external distractions. They don't have somebody, they're not checking email as much. They don't have people coming in and out of their offices. They're not working on other things. They're focused for that mediation on this particular case. When you're doing this virtually, I imagine there are not only the distractions of home, but there's the distraction of email and work and everything else going on in the background, especially when the mediator is caucusing with another party. Are you able to keep people focused on an in-person mediation, like an in-person mediation? Susan, if you'd like to take that.
I haven't really had a difficulty with that. What I say to them in the beginning is I address just what you said, Jennifer. I know you're home, you probably are here, you're pulled in 2 or 3 different directions. But what I say is, when I'm here, I need you here in an undivided way, the same way I am here, totally focused. So if you have that, do it. And then when I'm coming in though, what I need you here is to have all that put away. And what I've been able to do is, depending on the views that you set up, you can see where they're sitting, if they have another device with them. I've been able, if you have, for an example, a gallery view and it's just you and maybe 1 or 2 other people, you're able to see a good bit and you're understanding their circumstances. So if you see them start doing this, you can say in a real nice way, is there a call you need to take or something like that? But what I do is really just talk them through and in a sort of a coaching kind of way say, when I'm here and we're focused, I really need you here because this is how we're going to be able to get your case settled. But so far it hasn't been a problem to getting a case settled.
I think that's an important conversation that attorneys need to have with their clients before the mediation starts, that they're not listening to external influences. They're not calling all of their friends and family and church members in between each offer to solicit other people's opinions, that they've hired a lawyer for a reason. They're entrusting a lawyer for a reason, and that lawyer's advice is what they should be listening to rather than crowdsourcing how to respond to every offer. The other concern that I had initially about the concept of a virtual mediation, and David, I'd like to ask you about this, is how do you create the tension that's necessary to pressure people to settle? There's nothing like being in a room with a client who's flown in from out of state with tensions high and everybody really, really wants to get the deal done. That's not the same when you're sitting at your house. How do you still build the tension that you need to create an incentive to settle?
Yeah, I do think the current situation has created enough uncertainty in everyone's life that there's a natural tension involved where everyone would like to see things keep moving both on the defense and plaintiff side. and it's impacting certain industries. I've had a couple cases with company defendants with self-insured retention issues where their particular industries, it was a real issue. The plaintiff's lawyer recognized there was not a lot of discussion about it, and honestly, the defense offered good money to get the cases settled, but lurking behind it is how long is this going to be going on and where is this headed? So that has created a certain tension of just a desire to move the case. No one really is talking about it much, but I've sensed everyone coming to the table wanting to try to get things done because it's just changing the whole atmosphere about how people are thinking about cases, and there's uncertainty about it, and people want to try to get something done.
And Susan, I'm going to go back to you because you and I had this conversation previously. Something I think you and I have both been thinking about a lot is how do cultural norms change after coronavirus? Does a post-coronavirus jury think differently than what we're trained to think?
Well, you know, we don't know that yet, and we won't know that for a while, but I want to give you an example from a recent mediation. And it was a trucking case, and I heard the typical, well, you know, jurors hate truckers. And I just instinctively said, not anymore. And I said, because they're the ones bringing us all the stuff we need to eat and the supplies we need to manage our homes and the things we might need to educate or clothe our children. I said, so not anymore. And it got me to thinking that I believe that there will be some changes in some cultural norms. That's just one example. I got to think, I do a lot of medical negligence cases. I got to thinking about how now these nurses and ED doctors and so many of them on the respiratory therapists, they're all on the front line, and how culturally I think that will change. So I think there's going to be thinking from that standpoint. I also think that as a culture nationally, while we may have gone through individually different experiences, we have all gone through the experience of uncertainty, deprivation, upending of life as we know it. Some of us lost. Certainly some people grieving, some people are angry. So we'll have to just see how those norms play out. But I think it would be fair to say when the entire culture has gone through this experience, the things that we have previously thought about the patterns of jury thinking may not be the same. So what does that do? It creates another uncertainty in your case, which says, if you can get this thing resolved once the courts finally open up and before we kind of figure out what the new patterns of thinking may be, it certainly is to you and your client's benefit.
We are getting ready to wrap up the mediation section of this. Greg, I did want to ask one last question to you, which is, has anything about the virtual mediation process surprised you?
I've been surprised at how intimate we can still be in sharing those interpersonal relationships. One of the things that mediators kind of take pride in is our ability to read the rooms, read the temperatures, and figure out the language with which to communicate with both rooms. We're not expert at it, but we take into a lot of visual cues. You heard Susan say when she can tell someone's looking down, she doesn't say, put your phone down. She's like, oh, do you need to take that? And that's a polite way to kind of course correct. What I think Zoom has allowed us to do is to be honest about our imperfection with it. One of the things I do, I don't lead with this, but during some of the downtime, I'll ask, all right, who's wearing shoes? Who's wearing pants? Who's in yoga pants? Where did you put your dogs? Jennifer, you and I talked earlier before we started. You hid your dogs 2 rooms away. My pets are locked out to keep them from coming in. Invariably in a mediation, someone's dog will come in, someone's grandson or granddaughter or kids will come in the room. And you just go with it. You talk to them. I've spoke Spanish in my very first virtual mediation. I spoke Spanish to the little grandson who came in and proudly sat on the grandfather's lap. And it just disarmed them. It made them more relaxed. And we got the case resolved down the road. So I think I embrace the imperfections of where we are and acknowledge that no one has it figured out. No one's doing it any better than anyone else. And we're kind of all in this together.
And the imperfections offer a great icebreaker. I've had many conversations where we have wound up showing each other our dogs because everybody wants to see what other people's dogs look like. And the fact that you're at home really does create a sense of knowing the person more than seeing them in a business suit at the mediation center when everybody is buttoned up and stressed out. So I really do appreciate your time on this. It looks like we're hitting the 2 o'clock hour on the nose. And I know that Andy and Ken and Greg wanted to move on to answer some of the questions. I see we have gotten a number of questions in. So Ken, I will kick that over to you then if you'd like to discuss some of the questions we've received.
Okay, can you hear me?
Yes.
Yeah, I had been muted, but in any event, yes, we'd like to take a few minutes now and take some of your questions. We won't be able to get to all of the questions because we have a good deal of them, but let me go through a few of these questions and then throw it to some of our panelists. Susan, this one's probably for you. When do you think civil jury trials will resume?
Yeah, I think that's an excellent question, and our colleague Joe Murphy and I have had a lot of conversations about it. And the number one premise is this: it's going to be very difficult by order or operation of law to compel a person to sit in a room with 11 strangers, you know, nothing about their social distancing practices, their health, their anything. And until such time as courts can be sure that we are not going to be spreading this virus by virtue of the normal court process, I think it's going to be difficult to compel people to come in. And that could be some time. And we certainly can't have a situation where only people who have a vaccine or only who have the antibodies serve on jury. We can't have that. And so I believe it's going to be a time until we are, as a culture, and people who are able to serve have either been vaccinated or are no longer at risk of either being sick or spreading this virus to someone else. I think that's going to be a longer time than simply when social distancing requirements expire. And then we all know this, the criminal cases come first. I mean, they have to because there's constitutional consideration. So I think we should prepare for months and months rather than weeks and weeks before we get to a jury trial. Even after the social distancing restrictions open up.
Which of course leads into what we were talking about with regard to the mediations. There's another factor. When the courts open up, it's going to be a long time before some of these civil cases get in there. The next one, I think maybe for Jennifer Markowski, a couple of questions. How do we effectively mark exhibits remotely? And are the exhibits produced to the court reporter prior to the deposition? Jennifer, have you run into that? Jennifer, you're muted.
Sorry about that. Okay, so I heard the first part of the question. So in terms of marking the exhibits, you can pre-mark them ahead of time for the exhibits that you know you're absolutely going to be using. I would coordinate with the court reporter on that, whatever service that you're using ahead of time, and you can obviously mark them as you go for those the inevitable exhibit that you weren't thinking about ahead of time and you realize that you need to mark as you go. There was a second piece to that, Ken. I missed
the second piece was, do you produce those to the court reporter prior to the deposition, the exhibits?
You can. I would say if you're sharing it with opposing counsel ahead of time, I would also probably give a copy to the court reporter, because why not do that? And I would, whatever way you're doing it, I think it makes sense to have that conversation ahead and agree to how you're handling it.
Here's one for David. Are you anticipating that clients large and small, being ever mindful of litigation costs, are going to push for more remote proceedings to save on fees even after the crisis passes?
Yeah, absolutely. I think you're going to see more and more on the defense side of claim reps and adjusters doing it remotely. It's way more efficient. And I've got an 8-party case coming up in a week, and we don't really know when the travel piece of this is going to be resolved, but I've got attorneys from, I think, 4 different states, and who knows when they'll be able to hop into on a plane and get here. So I think of necessity, absolutely, we're going to see that.
Great, thank you. Greg, here's one for you, and you touched on this in your piece, but maybe you could just review it quickly. Would you please explain the logistics of mediations, chat rooms, separate meetings between the mediator and each client? How does that work on Zoom?
Absolutely. The simplest thing to do, and I could show you when we do tutorials, but I create rooms. The Zoom platform allows us to create as many rooms as we need. And what I found is you do need 2 extra than the number of parties you have for this reason. If we were live at Miles Mediation, I could pull Ken out of his room, I could pull David out of his room and let them talk in a third private room or just out in the hall. With the Zoom platform, I have to create another room so I can move those 2 in. And one thing I didn't encounter, and I learned after my second mediation in this virtual platform, is there's also a need to be able to talk to the plaintiff's attorney away from his client, and sometimes the defense attorney away from their adjuster. And so that's the reason why I create more rooms. Some of the things that people are asking questions about, they're great questions, but I tell you in this way, not in a condescending way, but in the same way you don't ask the pilot all they're doing, some of the things we try and make it as easy and seamless for you as possible. So we set it all up so that you enjoy the same experience you would as if you were there. When you come to Miles Mediation, we don't show you where to order the food and how we got it and how we set it up. We just do it. And that's what we try to do there. But to answer those questions specifically in the tutorials, I'll take you through it. I can show you the screen share. It's just the button at the bottom where everyone does it. And you can screen share. You can come up with not only what you want to show on your desktop by way of a presentation, but also a whiteboard. So if you want to show the tally of numbers or explain how to use a bracket or to show a Venn diagram, you have those abilities.
Well, here's a follow-up that may be asking the pilot too many questions, but I'll read it. Ask Greg if he's wearing a Carolina blue t-shirt under his dress shirt.
I think I know who that came from, even though these are anonymous questions. I am not, but I have 2 Carolina cups, so coffee, water.
Okay. For any of the Miles folks, maybe Susan, do the mediators charge for these first training type sessions with the parties ahead of time?
Not at all. In fact, we encourage them. We believe these are for the benefit of everybody. It makes the whole mediation go more seamlessly, and I think it makes us all more effective. And so, no, we're happy to do them. Not only, as David said, do we kind of get to meet them early on, not only, as Greg said, that are we able to kind of go through and do a tutorial, but more importantly, to me, I feel like when we start that day, we all have a comfort level with what we're about to do, and we can get about the business of getting the case settled. So no, we do not charge for those. It's our privilege to be able to host them with our clients.
That's terrific. David, how about this one for you? Are your virtual mediations lasting longer or shorter than the old mediations?
Honestly, really about the same. I'm about a decade older than Greg. There's no way I can sit in a chair for 7 hours. Impossible. I would have to have an ambulance come get me. So, you know, I'll get up and take a few steps just to move around, but it takes about the same. There's a pacing to these things, and you know, no big secret here. A lot of times a defense attorney or a plaintiff's attorney will say, hey, don't rush right back with that, you know. We all know that. We're professionals. So there's a delay factor of a few minutes here and there. And I'm finding, though, the ones that are going to get done in 3 hours get done in 3 hours. The ones that take 7 hours take 7 hours. It's about the same.
Great. Jennifer Markowski, here's a deposition question. How do we as attorneys sit with our clients to defend a deposition?
So obviously you're doing it virtually, and I think you've got to talk with them ahead of time about how to have the separate conversation. That's why it's important to have their cell phone available, that you can, you know, if you need to check out of the live conference and go have a separate call where nobody can hear you, nobody can see you, be prepared to do that, and be prepared to have the upfront preparation with them to go over how all of that will work. But I have found, I know Zoom has the ability to set up these separate rooms, but I have found that using just a phone conversation off camera while muted is a good way to have the private conversation.
Great. Here's one for the FMG crew. Any special tips, problems for remote arbitration. I don't know if anybody has done that just yet this time around, but Jennifer or Andy, you want to talk about remote arbitration? You're muted, Andy.
There we go.
There you go.
And so I see Jennifer Adair was starting to talk too. And Jennifer, you may want to unmute. I haven't yet done a virtual arbitration. My gut tells me that you need to be looking at the same considerations we've talked about for depositions, and that you really need to be thoughtful about preparation. I'll try and kind of wrap in two questions I saw in the thread as well that may tie into this. We had a question about depositions and what formalities might apply as to the location of the court reporter or the notary. The answer is, from a technical standpoint, it probably varies from state to state and day to day as governors begin to enact emergency orders permitting remote notarization, placing witnesses under oath remotely. From a practical perspective, there's no need to get into the technicalities. What you need to do is just have a very clear and frank conversation with plaintiff's counsel up front. Assuming everybody has agreed to a virtual deposition, nobody wants to do it and then not have a usable work product. And so several of us have had stipulations that we've entered into that we're going to waive formalities as to, the actual swearing of the oath that will of course be conducted, but nobody's going to raise a technical defense to that later.
Okay, Jennifer Adair, did you have something you wanted to add to that? You're muted. Okay, she can't talk right now. Folks, the rest of the questions are fairly technical in nature. How do I set up Zoom, this, that, and the other? And I think that probably is best addressed offline. So Andy, I'm going to throw it back to you. But before I do, I just wanted to add my thanks to everyone else, for everybody who participated today. Really enjoyed being able to speak with you about this and hope that it's been helpful. Andy?
No, great. Well, thanks. And first, as we conclude, I just want to make a special note of thanking Greg and Susan and David and of Miles Mediation for taking the time and the energy to join us today. We really appreciate the insight and experience that you bring to this and look forward to continuing to work with you all in the future. I think somehow in the last 2 or 3 days, I've wound up talking with each of you about cases we've had or are going to have in the future. And I want to thank behind the scenes their marketing team and our marketing team for helping with the logistics of this.
Thank you, Andy.
Thanks, Andy.
Thank you, Jennifer. We appreciate it.
So to the participants, we did get a question on the chat menu about whether there will be CLE or CE credit for this one. Unfortunately, there's not. That typically requires pre-approval, and we felt this was timely enough that it was important to go ahead and get the presentation done. And accordingly, there are also no written materials. However, in the next 24 to 48 hours, y'all will probably be getting an email with 1 or 2 pages with bios and contact information for all of the panelists here today. We will include a link to the Miles Mediation website, and we are going to include a link to Freeman, Mathis, and Gary's website, where we have set up our archive for our coronavirus task force. And I've got to tell you, our team across the country in all disciplines has been working to try to make sense of what the legal changes are going to be in a variety of disciplines. And so whatever your line of work, I encourage you, go to that website, because if you've got a question and our team has answered it, hopefully we can save you some time. If we haven't answered it, let me know, because if you have that question, then 3 other people do too, and we'd love to handle it for you. And finally, just kind of one personal comment. As a panelist, I have an opportunity to pull up the list of all the participants. And as I scrolled down the list a few moments ago, I saw colleagues at my firm. I saw former colleagues. I see opposing counsel. I see adjusters and clients. And we are obviously here to help move your claims forward. But more importantly, we're here to work together and get through this all together. So everybody, please stay safe, stay healthy. And we look forward to working with you very soon.
Thank you, Andy. Thank you, Jennifer.
Thanks.
Thank you, everyone.
Take care, everybody.
Thank you.